Trial? Are you ready for trial today?
I am.
Okay, all right.
Sarah Boone walked into the Orange County courtroom wearing a blue dress shirt, slacks, and jail slippers. After a week-long delay due to Hurricane Milton, jury selection for her trial began Monday. Boone sat before jurors without handcuffs.
You want to choke me?
It's evidence like this cell phone video that the state and defense would rather potential jurors to have not already seen.
Has anyone seen a video of a man in a suitcase?
There was a series of questions from Judge Michael Kranick to see if potential jurors had already seen the cell phone video, the interrogation video, and the body cam video from when deputies responded.
Body-worn camera videos in which Miss Boone is speaking to police. Do you have such strong feelings that you could not be a fair and impartial juror? If you have those beliefs, please raise your paddles at this time.
All right. Well, that was from yesterday, you guys. Welcome in, everyone. Carrie is here with Sam again.
Hi,
How are we? So yeah, yesterday they ended up dwindling it down. I've done a couple of updates on this, but we had what, 23? I think that was the total number at the end of the day. And now they've just gone to lunch. Well, they've sent the jurors to lunch. They're shooting for a 50-person panel, but out of the 50 that came in this morning, they have now had their qualified jurors up to the number of 43. So they just need 7 more. So I believe what's happening now is that they're going to bring in the remaining 50 for the rest of the day. I'm not sure of this, but I think this is what's going to happen. They're going to bring in the afternoon 50, and then they're going to find their remaining 7. And then they're going to go into what is called peremptory strike. I think it's what you said. Peremptory strike. Am I saying that right, Sam?
Peremptory challenges.
Yeah.
Or strike. Yeah.
Do you want to explain so I guess I want to explain it from the beginning. So here's what happens. They don't need the jury in the room for this, right? Am I right?
Well, what happens before they send them? Okay, I'm trying to think about how they would do this because they have so many potentials, and I've only ever had a trial where we moved to a big courtroom and did everybody all at once. So if they're going to bring the next panel of 50 in, and then they're going to get rid of everybody that they stipulate to, right? And then it'll be like the first 7 or so, I guess, that they're choosing from, maybe.
Yeah.
And then
will they send them out of the room after? Let's say they get that 7. Are they going to send the jurors out of the room while they sit there and do their whole strike thing between the lawyers?
Send them out of the room to fill out. Like, let's say they get to their final panel of 50. They will take that chart, like the one I sent you, and they will start writing the information based on those juror questionnaires. Okay. Then those 50 people will come back in. And then they start judge asks questions. I think he said he had like a 2-hour thing. And then each of the lawyers asks questions. When that's all done, they send them away. And that's when they start the striking process.
And then they could come back as early as tomorrow, I guess.
Yeah, it's a lot of work to get done in an afternoon, but yeah.
I mean, it would make sense if they did, though, so they could get rolling in the morning. I would think that when they get to that point, the judge might extend the day a little bit today so that they can finish up, right?
Yeah, I mean, if they're close, I would assume, yeah, he would do that. Now, remember, though, he had the jurors from the ones they kept from yesterday call in to see what day they would come back. So he can't now say that you have to come back today. So I think we're in jury selection one more day.
After today? Yes. Really?
Yeah. I do. I because of what he said yesterday, right? He sent the third. How many did you tell me? I'm so sorry. How many did you tell me they had from yesterday?
They have 23 from yesterday.
Okay. So those people were to call in this morning. Yes, hi Fawn Fargo. Sam messed up on the jury count because I usually am working on first-degree murders and not second. And first-degree murders have 12. And second have 6. So yes, you're correct. And I was wrong. Okay, so they had 23 that called in this morning to find out when they need to come back. They didn't need to come back today. So they were probably instructed to call in tomorrow. My guess is if they get to the math 33 they would need to complete the 50. If they get to there today, then all 50, the 23 from yesterday and the remainder from today, would be brought back in tomorrow.
Okay, so what do they do when they sit here, when they do these strikes? What's the process of that? Sam had sent me a photo of what this looks like. It's kind of cool, you guys. I can't send it to you until I work on it, some graphics on it, because it's got people's real names on it. But it's kind of interesting to look at. It's like a legal sized paper with
Bigger
boxes.
than that. It's got like 4.
It is.
Yeah, it's
huge.
It is.
Oh my God, it's the size of your pillow. So it's got
it's got
boxes in it.
It's got like 1, 2, 3, 4, like maybe 6 pieces of paper taped together.
Okay.
It's really big.
And then what's in each of the boxes? It's their name and
okay. So if you look, on what I sent you, and you guys were gonna try to get you one. I can't have Carrie put this one up because it's from a recent trial and there's people's information on here. But if you look, Carrie, down at the bottom left, see it says number 1. There's a big X in it, but it says number 1, and then number 2, number 3, number 4, and so on. So those are going to be from this trial that I did. Those were their numbers that they were given, and they filed in that way so that we could track them. You see what I'm saying?
Yeah.
So the numbers match. So then this information, like their names and a couple of the little check boxes, we got some of that information out of the juror questionnaires, which I also sent you a juror questionnaire.
Yeah.
So we had a lot of time and we filled this in. Okay. And then they brought all 75 of these people in. And then they started the strikes that everybody stipulates to. And then they started with the other ones.
Let me show a picture really quick before I forget, because I did already. I thought I had recorded it. I've been prepping all morning, and apparently I've gotten 0 done. I want to share X. Oh my God, I'm frustrated this morning because I'm just not where I would like to be. Okay.
Oh, is that her outfit today?
Yes, this is what she's wearing today. And it looks to me like it's brown and green, but they said gray and turquoise. And I can't tell, is that a skirt or pants? I think it's a skirt. It looks like a skirt.
Oh, she's got shoes. They're checking the shoes.
She got her some little flats.
Mm-hmm.
I hope she gets blisters. Yeah, ballet flats. How difficult can it be? Just put them on. Shut up, Sarah.
She's probably still got ankle chains on.
She was asking for more snacks. I'm like, are you kidding me? Isn't that her lawyer's job to make sure she's got everything?
Asking for snacks? What?
That's what I heard on Court TV, but I don't know. I haven't seen any video of that yet. There's no sound to this, by the way, you guys. So I don't know. I'm not sure. But yeah, that's it. That's the video. I'll leave that feed up so that you guys can watch it while we're talking.
I'm so sorry. I can't imagine Kranick allowing snacks.
Well, no, I get like maybe she wants something. I don't know. I don't know a lot about it. I don't even know if it's true. I saw it on Twitter and I thought, is that old or is that new?
Gotcha.
But it wouldn't surprise me though. You know, with her, she's like, I need water. Like everything that's going on, all the important things that are happening around her, and she stopped the court to say, I need water. Mm-hmm. It just blows my mind. Yeah, queen for a day. You're absolutely right. Juan Fargo. Okay. Mm-hmm. I'm sorry to interrupt you on that. Go ahead and finish what you were saying.
Okay, so they'll bring in 50 people tomorrow that they have cleared between yesterday and today. And it's not like, and they'll line them up and they'll each have a number, and the lawyers will probably get a square box thing, just like I sent you, that we're gonna get for you guys. And then that's where the real specific questions start. And it sounds like the judge has his own thing he goes through. And then you, as an attorney, like, I sent you the questionnaire. So from the questionnaire, like, that's how I was filling in my boxes. And then I was making additional notes when they were called. But then I think I started doing something else, so I may not have finished it, which is par for the course for me. But you can see all my notes on there and stuff. Some of them came from the questionnaire, like I sent you.
Okay.
And so they'll do the striking, the striking part, in my experience, in my courtrooms, in my county, has never taken place in front of the actual jury.
I can't read your questionnaire, the one that's got the big X in it. I can't, it's too blurry.
I'll send you a better one.
Okay. Sorry about that.
That's fine.
So, what do you think they're going to ask? What do you think is going to happen? What are they? I don't know if you you're you're used to being on the defensive side. Like, what do you think they're going to be looking for?
They're gonna, well, obviously they're gonna ask about the publicity, if they've seen anything. Then the next thing they're gonna ask is, and these are gonna be the basic ones.
But that's already been done. Okay, we got the publicity. That one's done, right?
That one's
that's
done.
Already,
yeah. Have they ever been on a jury before, civil or criminal, and if it was tried to completion, and if they remained on the jury? Are they law enforcement? Is a friend or family member law enforcement? Have they had bad experiences with law enforcement? Do they trust law enforcement? Things like that. Because some of these people will check, yeah, they have something to do with law enforcement. So then the attorneys are going to go and say, okay, tell us your involvement with law enforcement. And, somebody may say, well, my husband works at the jail. And then we're probably going to, the parties would agree to remove that person.
Gotcha. Okay.
So it'd be something like that. And then there will be, have you or anyone else in your life, friend, family, been a victim of a crime?
Oh, yeah.
And they'll put that, and they'll answer to some effect on their questionnaire to that. And then, has anyone, including themselves, have they been accused of a crime?
Gotcha.
And so, like, I'm looking at this sheet for the notes that I was taking. This trial was just before I met you in August. I had just finished this trial. Like, I have a note for one person that she had been a victim of a crime, and that she had been a witness, and that she was also really impatient and had been dismissed before and was talking too much.
Oh.
The next person on there next to her, like, that I have highlighted, my note was takes very seriously. Then I have somebody on the other side of the one that I said talk too much. I have political views written down for him, because
so what you're talking. So what you're saying here, these little notes you're talking about, these are the things that all of the attorneys are going to be making next to their little boxes, in their boxes.
Right. So, like, the names and the numbers and some of this basic information where you can see occupation, spouse, if they've ever been a crime, blah, blah, blah. All those little boxes, that should come off the jury questionnaire.
Mm-hmm.
And then all the other stuff you're seeing, they're just randomly selected and asked questions. And then, in my experience, again, in my county, in my courtrooms, once everybody's happy with having asked questions, they send them all out, and that's when we start with the X. You see the X's? And you see how 1 and 2 on this chart are gone? And then 1, 2, 3, 4, 5, 6. So the first 6 there, if they didn't get struck, then there's your first 6 jury members.
Okay.
Do you see what I'm saying? It's not a pick from up here and a pick from down here. It's like literally from the first person, that's not stricken, all the way through. hope that makes sense.
so basically, but that's the defense's view. So the prosecution's going to have their own little thing of boxes, aren't they? And they're
Right,
going to go.
but the questions are exactly the same. They get the exact same juror questionnaires. The form is going to be exactly the same.
No, what I
They
mean is in the boxes, in the box sheet, the prosecution,
Mhm.
their jurors that they want the note in a row, like their picks in a row are going to be different, or is it the same?
No, they're gonna. It's not so much selecting a jury, I feel like, as it is negotiating to a jury, because each side is fighting to keep one that would be beneficial for the other side out. So if we wanted somebody and they knew it because that person looked good for us, state's going to try to find a reason to get rid of them or use one of their own challenges to get rid of them. So it's a bargaining thing. Like you're trying as the defense to get rid of jurors that might be really super favorable, what you think would be favorable to the state,
Right.
and vice
Yeah.
versa.
Yeah, I get that. Okay. All right. Well, let me go through the Twitter feed really quick, you guys, of what's going on this morning because I've been keeping up with that. So this is all before lunch, okay? We've got the update, of course, on her outfit. And the breaking news of the day was that the hooker did get to shower and she has flats on. You saw that already. Uh, again, there's a contradiction between what I see she's wearing. To me, it doesn't look gray. It looks brown.
To me, it looks gray.
Does it look gray to you?
Mhm.
Okay, maybe it's my computer screen. It could possibly be my computer screen. Okay, and then the other thing was they were talking about him initiating these little fist pumps with her to psych her up. And Owens had told somebody there in the media in the courtroom that he is anxious to get the trial started, or she is anxious to get the trial started. They're likely to get a jury by the end of the day or tomorrow morning. Kranick asked jury pool, what is a person's biggest fear? And when they, he said, it's public speaking. And they were like, oh, okay. So I don't know why that was something he said. But anyway, many potential jurors were bailing out this morning. When I say bailing out, they all had travel plans. A lot of people had plans to travel in the next 3 weeks.
Mm-hmm.
And then they also made notes that Sarah was quite fidgety this morning. She was flipping through legal papers a lot. And they didn't think she was wearing her ankle bracelets this morning. So no restraints at all. Because you could see her kind of moving around a little bit, but I'm not sure. I don't know if that was, my thought was that was before, because it looks like these pictures that we're seeing, this is right when she got in the courtroom.
Okay.
So I kind of wondered if they ended up shackling her before the jurors walked in, or the potential jurors walked in.
So normally, I mean, we've been through this with the hearing and everything, but I just want to make it clear. I said it at the time, but if she takes the stand, the jury will not see her walk to the stand under normal circumstances because they are shackled. So what would happen is the jury would be sent out for a break. The defendant would be put on the stand with nobody in the courtroom. And when the jury comes back in, that's where they'd be. Do you see what I'm saying?
Right.
So they don't see them walking.
Okay. Yeah. No, I get that. I think it's weird that this morning they didn't have her shackled. But I feel like they let her change because I think she just gotten this when these pictures are taken. I think she had just gotten her outfit on. She had just gotten the courtroom because I think that was the only time the media was allowed to record anything.
Okay.
And then once they went into session or whatever, then they shut the media down. That's what I don't know, but they could have shackled her before they let the potential jurors walk in this morning. Is what I'm thinking, because she is supposed to be.
Well, she would have to be
Kranick.
unshackled to be dressed.
Yeah, exactly.
But remember, he did ask for no restraints, and then they had settled on those stun cuffs. I don't know where they are with it. I'll try to find out if I can. I just wanted to highlight this comment because I feel like we both need it today from Mary Jo Freilich. You guys are a terrific duo. I love the Carrie chat and the Sam explanations. Thanks so much for presenting this for us. Thank you for watching.
Thank you
We
so much, Mary
appreciate it.
Jo. Okay, let's see. Yeah, a lot of people are pissed, and I know, like, on Twitter, a lot of people were really pissed about her being able to, have all these different perks and stuff like other prisoners don't get.
Yeah.
And, I I mean, it's like you ask and you shall receive. I guess she's just a pain in the to me, it's like if she wants something to eat or drink while she's sitting there at the thing, I know she probably can't eat and drink in front well, she can't eat in front of the people, but, like, her lawyer should have brought her something if she wanted something like
Well,
that.
at the defense table, and obviously I've never worked for the prosecution, so I can't talk about that. But at the defense table, in most of our courtrooms, there has been like a water thing, right? And plastic cups. And the defendant is allowed one of the same pens that they can have in the jail, which is like the inside of a pen, not the actual plastic part of a pen. And
Yeah.
there's usually an armed deputy immediately behind the defendant, which can make things crowded sometimes because I work with 2 lawyers, and the last trial we had was 2 defendants, 3 lawyers, and me at a table. So that was a lot of people.
Oh,
But eating in a courtroom is highly frowned upon, as is gum chewing.
hang on, guys. I got to get Frankie moved. Hang on just a second.
Okay, Linda O'Gara. I'm not sure where you got this from, but I'm going to go ahead and read it. I'm assuming you got it from Twitter, maybe. Court on lunch, update 43 hours so far. I don't know what that means exactly. State received 500 pages from defense last night regarding Georgia's medical received. State will have hearing Wednesday morning, 50 more hours tomorrow afternoon. I don't understand the hours part, but maybe you can put another comment in and tell me, please, where that information is coming from, because I don't have a source.
Yeah, I don't, y'all. Unless we have receipts, I don't even want to talk about it.
Okay.
I don't even want to bring it up. So,
Okay.
we
No
need
problem.
there. You know why I say that? Because there's too many things. There's too many people that misreport information.
Yeah.
And it goes from one person to the next person, and before you know it, you've got fifth-hand information being reported on social media.
Yeah, it's like that game of telephone, right?
Exactly, but it's like totally strung out. So unless we know for sure, unless I see it, I'm not going to talk about it.
Okay.
That's just me. That's just me,
No, I agree with you. That's why I said I don't know your source for the person that put that.
I've got okay, so the state did finally do the response for the motion in limine. It just hit the docket because I didn't see it. Or I did a refresh like within the last hour. So that's the only thing that's come up on the docket. I guess let's pull this up and talk about it.
Matthew Whitehair, thank you for your super chat.
Is this what you were talking about?
What's that?
Thank you, Matthew. Someone in courtroom said no restraints at all. Yeah, I heard that. That's what I heard on Twitter as well. I saw that.
I'm
One of the
seeing
media
a lot of
outlets
people
reported
say that. I'm seeing a lot of people say that. That would be a first for me. Everybody I've ever had has their ankles changed.
Okay, let me screen share so we can. Let me screen share so I can show you guys this.
Blanco's been a member for 12 months.
He has.
You. Happy anniversary.
He's been here a long time. Okay. Can you all see this okay? Let's put Sam and I off the screen while we talk about this, and we'll take off. That's not what I want.
You gonna take the banner off?
Yeah, I am. Trying to get there. Trying to get the screen as big as possible, but I guess that's as big as it goes. Okay.
So people are saying there's, like you're bringing up, there's new information on the docket.
Yeah, I'm getting there. Give me a minute. Okay, so it's saying that state's objection and motion in limine to exclude decedent's medical records. What? Exclude them?
The state doesn't want them in. It's the state's objection.
Why wouldn't they want that in? That doesn't make sense to me. Let me because you know what? Remember you had brought this up that he had said the last time they were in court, he said, "We just got these records. We haven't even had a chance to look at them." And you had made the comment, you were like, "Yeah, they've had them for a long time and they're just now getting them." This says this tonight the state received 550 pages of medical records regarding medical treatment and the decedent received in 2017 and 2018. The defendant acquired these records in January of 2022. The defendant did. The state adopts all the arguments and authority cited in the state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. The defendant, even in her most recent iteration of what happened on February the 23rd of 2020, has not set forth the legal grounds to claim self-defense. Assuming that she does not so at trial with a different version of events, then prior incidents of violence committed by the decedent that she was aware of would be admissible to show the reasonableness of her fear of imminent greatly bodily harm or death. These records are irrelevant. 487 pages regarding an incident on December the 24th of 2017, where the decedent was beaten so badly he needed facial reconstruction surgery. That was the fight he got in with his brother. This is not relevant to whether the decedent committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, the severity of the decedent's injuries is not relevant. If the severity of these injuries is somehow relevant, then the defendant should narrow it down to the pertinent narrative history of what the decedent said happened and the treatment provided. This could be done in a handful of pages. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hands through a glass window the day before, and his wife made him go to the doctor the next day. He received 2 sutures to close 4.5 centimeter laceration. Assuming that the defendant testifies in a manner to make that incident relevant, a couple of the pages of these records with the narrative of what allegedly happened and the treatment provided is sufficient to corroborate her testimony. I get what they're saying that because they don't want it to look like he was, if you hear that he put his hand through a window, then people are going to be like, oh, he was real.
Right. So with
reckless.
that quantity of paper, that's subject to misinterpretation, but also when you request medical records, I don't know if you've ever gotten them for yourself or for anybody else, there will be pages and pages and pages of like post-release instructions and just nonsense that has nothing to do with the actual injury. So instead of culling that file down to what they may have wanted in, the defense just dumped the whole thing. And I think that's ridiculous.
Yeah. Okay. So burying the jury with 550 pages of records when nearly all of them are irrelevant when giving the defendant every benefit of the doubt on relevancy is unnecessary.
Yep.
And the probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence.
That right there, that piece you just read, that is the rule of evidence that, in my opinion, as an investigator sitting in on cases, that is the rule that I see most often. In Florida, it's 403B, I think, which is you can't inundate the jury with a bunch of crap that is repetitive. So, for example, in the Karen Reed trial, they kept having people testify the same stuff over and over and over again, and it was not necessary. And I don't know why they didn't object and get rid of it, but that was a mess anyway.
It is a tactic defense uses to confuse them. That makes sense. Therefore, the state objects to these records, barring their relevance being established at trial and their probative value not being substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence.
So that
was from Jay.
The evidentiary question is posed: is it more prejudicial than probative? If it's more prejudicial, then then maybe it doesn't come in or only portions of it come in. If it's probative more than it's prejudicial, then it can come in. I hope that makes sense.
Yeah. Okay. All right. So that's that part. That's the only other thing on the document right now. I think that they're, you know, he's going to say, oh, he was dangerous, blah, blah, blah. But I guess nothing. Here's what I think the defense is going to say. The defense is going to come back and say, well, we need to see if there was any underlying factors with his health that caused him to pass away, and that it wasn't him being in the suitcase. So I feel
Yeah,
like
I see some of chat saying that too.
It's going to be a bounce back of that. And then,
okay.
And
yeah,
then,
that makes sense. That totally makes sense, Carrie.
So that they're going to have an argument on that. Well, I say argument. It's going to be something that they're going to probably work out before they get everything rolling. But
chat is saying there'll be a motion hearing in the morning. Because I don't think the judge has even ruled on the battered spouse, has he? What's the last open motion in limine? Did he rule on that?
I don't know. No.
I have to go back and look, or chat can tell me. I thought there was one outstanding question that he had yet to answer. But also, my brain is like scrambled eggs today.
Well, the last
motion... Okay, so Northwest is saying BSS needs a hearing. That's what I thought. Okay. That's what I thought. Yeah. Mm-hmm.
Yeah, the last motion in limine was about them trying to do take out a lot of the portions of that interview, which I had pulled that up, and I was actually trying to get that done this morning, and I couldn't get it finished. But it was like the pieces that they were pulling out from the interview, and then at the end of that was the part about the battered spouse syndrome. But they've addressed that here. In this document, isn't this them addressing that, where they're talking about how, where did he say it at?
That's not a judge's order.
Oh, you're talking about the judge's order.
I think we're missing a ruling on a key piece of evidence, or a key piece of this trial. Zombie Plan, thank you for your $5 super chat. Kranick probably asked about their biggest fear due to claustrophobia in the suitcase. I thought about that too. I think that's a really good point. Thank you for your super chat.
This is order declaring defendant indigent for cost and authorizing due process costs.
I don't know why they refiled that. I have absolutely no idea, unless additional items were added to it, or the date needed to change. Nunc pro tunc backwards.
It says it's done and ordered as of September the 2nd, so I don't know what that is. Okay. But that's the only, unless it just hasn't hit the docket yet that I can, on my side.
No, I think there's a hearing coming on something. I need to look and not just speculate. I need to look. I think there's something outstanding, a big piece that's outstanding. And I could 100% be wrong, because I was without contact to the outside world for a week. So maybe I'm wrong.
Let me go down here to the... Let me just go down here to the...
Bama, don't be in a bad mood, honey. We're here to entertain you. I'm sure I will say or do something really stupid, and that will make you laugh. Johnny Depp ate candy. Yeah, Christine Garcia. Yeah, he sure did. Johnny Depp was afforded a lot of things. CB's not in a very good mood either. Sorry to hear that. I hope we can give you a chuckle or some educational information today.
It's just at 9 a.m.
Are you cranky too? Sorry, Carrie. Chat's having issues today. They're not well.
They don't have anything on the docket as far as like any hearing set yet that I can see anyway. I'll keep refreshing it though while we're on here, you guys, and see if it comes up.
I think there's a hearing missing. I'll look. Thank you for your super chat, Matthew. White hair, moment of silence for George.
Yes, absolutely. I tell you what, I'm going to go why don't you go in and look for that, Sam? And while you're doing that, I'm going to go over to this Reddit thread.
Yeah, the Reddit thread is pretty interesting. Okay.
Let's talk about Juror 35 real quick. And while Sam's going in to look at that, let me pull it up. I got to go into my history here. Why did everything go quiet so all of a sudden? Can you guys still hear me okay? Can you hear me now? Can you hear me now?
I muted myself.
Oh, it's your background noise. Okay, I got you. Let's see. I had this pulled up yesterday. And whoever alerted me to it, thank you so much. Thank you so much. It was in this one, I believe. One of these Reddit threads, I was trying to give them like information of the interviews and stuff, and they were like, they won't let you post your channel stuff on here.
Do you have it? I can text you a link.
Oh, I'll get it.
Okay.
I'll get it. It's here somewhere. I just saw it. I just had it pulled up. Don't text. Yeah, because if you text me, I'm on my computer. I'm not. Here it is. Juror number 35. It sounds like it should be a song, doesn't it, guys? Like Mambo number 5. Here it is. I found it. And here's the thing. I went through and read this last night, and it sounds really legit. It does sound legit. Okay, so I'm going to start from the top and go down. And it just says, I was juror number 35. If you have any questions on how the day went, ask away. I obviously got dismissed for my knowledge on the case. Now, I'm just going to try to read just this person's responses to the different questions and whatnot. And she said, I really wish I could have to sit in on this trial because of my knowledge, but I also believe everyone deserves a fair trial, and it would not have been fair if I was sitting on the jury. And then she says, I feel like it'd be so hard not to look up the case after you found out the names. Oh, like she wouldn't be able to hold herself back. Or he. I don't listen to local news either. Somehow come across this one, and it was literally down the street from me. Wild. So she's only been watching it like on social media and stuff. In a previous comment, I said that she seemed arrogant at first during introductions, but it could have been because, now she's talking about Sarah Boone. It could have been because she was hoping no one knew about the case. Only 3 of the 50 ended up, she's talking about the jurors, only 3 of the 50 jurors ended up knowing anything about it, it seemed, I guess. And then she says, I was not looking at Sarah at the time. I was making eye contact with the judge since he was the one that was asking the questions. She said, well, I think she's guilty. I put a lot of things at risk if I'm not honest. Yeah, exactly. She said something about Cranick doing something with the jury panel. He seems like a great guy, awesome and fair judge, and I like how he makes them come up with the cases to support their arguments. Very smart. Then somebody asked her what was she wearing. Oh, this is so, y'all, this is so eye-rolling. She was wearing the blue top she wore last week. No notable hair or makeup done. And then it goes down to say she was standing there, but there was a wood wall, so you couldn't see her, or at least I couldn't, as I'm short. Maybe someone in the front row could have seen her. It's been said that she has slides on from the other accounts. She was not handcuffed, but I'm not sure about shackled. When she introduced herself, she made eye contact, but apart from that, I was weirded out by looking at her. Kind of like if you see someone from a distance, you don't really want to see them. You're looking at, let them see you're looking at them. I felt guilty in my own ways that I knew a lot about this case, so my eye contact and looking at Sarah was minimal. And then she says, it's been reported. Yeah, she's already said that. Okay. So then she said, Owen's 2 co-counsel and a juror consultant were there, and the guy directly behind her, which I bet she's talking about either the other co-counsel or she might have been talking about
Billy's there.
Billy. And she said, we did not get introduced to anybody, so I'm not sure. And she said, it did seem like the judge read it was a murder trial. And this is interesting. And the judge asked, have you seen the video of the man in the suitcase or body cam or interrogation? The tone in the courtroom shifted. They dismissed us again. And then we sat outside the courtroom and everyone kind of just had a stunned look on their faces. Can't describe it. Maybe like an oh shit type of look. No one said anything, but it was a general vibe people were giving off that this was a serious case. And I think that's out. She said judge was asking all questions. I think in some of the ones some attorneys may have had, but they did not ask me any. And she said they had the opportunity to ask me questions, but they did not have follow-up for me. I was very forthcoming about my knowledge. I think they may have agreed to which questions to first ask, but were asked by the judge instead of them. I do think that there will be another round where they will get to ask more, but I was not part of that. I was bummed, but I knew 100% that I was going to be picked going in. I was not going to be picked going in. So even going in today, I was like, if this is the Sarah Boone trial, I'm getting dismissed. And let's see. It's just a kind of a back and forth. She said, it was cool, even wilder that I knew a lot about this case. And then I got to be a part of the process. We waited from 7:30 to 9:30 and then went up to the courtroom. We answered questions and got dismissed from there. And then she says, Owens, nothing notable about him. Well, okay. He mispronounced a name and asked the prosecution team how to say it. They seemed unified. Oh, I'm sorry. They seem united with SB. She said he has nice pauses when he talks to the jury, which is reminiscent of Barack Obama. I think it makes it impactful, thinking personable, not like overly friendly. The extent of what we heard was introductions, him reading off the list of potential witnesses, and I think that was it. So very minimal. Oh my gosh, has nobody asked her about the witnesses? I want to know.
What do you mean asked her about the witnesses?
She said reading off potential witnesses. Can she give that information out if we asked her on Reddit? Do you remember any of the names on there that stuck out to you on the witness list? Because you remember we don't have it.
I know. I don't know the answer to that question. I know that when I'm in a trial, I don't talk about it.
She said, it is tempting. I know I have so much knowledge. I listen to all the motions and hearings, so it really wouldn't have been good if I didn't tell the truth. Plus, I probably couldn't keep track of what was submitted in court and wasn't, and what wasn't.
Exactly.
That sounds like me. I would have loved to have known nothing about the case and go through the motions. I hope to one day, but today wasn't the day. And she said that, anything else here that we need to say? She said, I was dismissed right beforehand, so I don't know what was said to those 11. I'm sorry. She said there was a whole other post on here that goes through the questions they were asked, which we've already talked about those. And she said they asked about hardships, jury service. Oh, so they've already asked about this, Sam.
Those would have been initial questions for sure.
Most were hardships. Most were jury service. Have they had young children they have to care for? Then there were some about the case. Have you seen the video and the man in the suitcase? Have you seen SB's interrogation?
So do you remember when somebody said stip and you asked me what that meant? That's stipulation. So that means that both sides stipulated to, if those questions were answered in a specific way, then the person could be dismissed.
Okay, I don't know about this case, but I think she had a video I started to watch yesterday and fell asleep. Now they're just talking about being on social media and watching the different people that have talked about Sarah Boone. They mentioned Grizzly. She said 3 to 4 weeks ago, I got summoned, and then you call in on Sunday to make sure it's still on. So called yesterday, and I was still supposed to report. Seemed more like a collection of me knowing everything about the case. The last series of questions they asked were, do you actively follow this case? And I said, yes, I do. And when the last time that you watched it, when was the last time you watched it or read something on this case? And she said, probably last week, the hearing before the hurricane. She said, I've been watching the hearings. That's funny. She looks the same in person, I guess is what they're asking for. She looks taller and broader. I was expecting her to be somewhat petite, but she seemed taller to me in person. Not creepy vibes that I felt, other than just knowing the case and having my own opinions. She seemed kind of approachable when she introduced herself with slight arrogance. And then she said, but I'm 5'2", 120 pounds, so I'm petite. And she looked bigger than me. It's hard to tell, though. I'm not impartial, so it's hard to say what the other people were feeling. She was also in the middle of the room looking at us. When jury starts, she will be turned around, so I feel like less impactful. Her presence was pretty normal, other than the first initial greeting. I think they don't think much of her, honestly. She did a smile a couple of times for most of the part, but scribbling, and she was being stoic. So I wonder, let's see what the question was is, I wonder how her presence and attitude in person will affect the jury. And that's where she said, I think they won't think too much of her, honestly. She did a smile a couple of times, but for the most part, scribbling and stoic.
Leah says, I didn't realize defendants introduced themselves. So I'll speak to my experience in the courtroom, which is the judge introduces himself, the state introduces themselves by just, they stand and say their names, and then the defense goes next. So attorney A will introduce himself, will introduce the defendant, attorney B, investigator me, and it'll just kind of go along like that. It's just, they do that because one of the first things they ask is, do you know any of us? Do you know our names? Have you seen us before? Do you know any of these people? Because if you do, like if you're married to somebody on one of those tables, you're going to be out. So that's why they have everybody stand up and introduce themselves.
Let's see, I lost my spot. She said, I knew it was a possibility with her supposed to pick her jury on the 7th. Initially, I thought I would be involved. Then with the hurricane, it got pushed back today. And I joked with my boyfriend or best friend, what if I got her trial? And we went to the 12th floor and I was like, I'm pretty sure this is the courtroom. They opened the doors and I saw her face, and that was really surreal. Felt really uncomfortable. Yes, she was in the courtroom facing potential jurors. From where I was sitting, I did not hear interaction, and her attorneys are only her juror consultant. Let's see. Yes, honestly, it was surprising. I felt that way. I thought I was going to be fine, but then realizing this is actually real and not just someone I'm watching on a show or a TV is another level. I got a little bit of a sickly feeling, and then in the same moment, it was gone. We had a job to do. So I think that's, let me see. Oh, wait, one more thing. She says, a group of 50 came in, got briefed. I think the first question he asked us if anyone knows of anyone in the courtroom. Then he ran down if anyone had hardships, spent a lot of time there and people discussing the judge. Then out of the room. Then a small line of jurors who made it through the first round. They asked the questions about the case. Have you seen the Suitcase video? Have you seen SB interrogation? Have you seen body cam? Then from there, we went back out of the courtroom and they called individuals back in. I was the third to be called out of the individuals and only know what they asked me. The judge kind of joked and said, seems like you know a lot about this case. And then he asked me, do you follow this case? And she said, yes, I do. And when was the last time you researched or saw something on this case? And she said, last week. And he asked both sides if they had any further questions, and they said no. The attorneys went to the bench and then sat down. He thanked me for my honesty and dismissed me. They knew going into that they were sending her home, but yeah. That's interesting. It's kind of cool to get somebody's view from inside of the courtroom, and she does sound completely legit. Let's see. Maybe if they have
she sounds right. I mean, I'm not disagreeing with anything. They do send them in and out to some extent.
It occurred to me, but I don't think that's right. She said, the question was, has it occurred to you to lie? Oh, no, I'm not even going to let her. She's like, I'm not going to do that. And they said, are you still going to watch it? Have you figured out it was this trial? Are you still going to watch it? She goes, of course. So that was about it from juror number 35. But we thought that was kind of neat. And somebody had sent me, somebody in the chat, whoever sent this to me in comments and said, go look, she's on Reddit. And they sent me the link and everything. So I was able to go in and look. So that was pretty cool, I appreciate you doing that and bringing that to my attention, because I wanted to read it before I really jumped on it. But I think last night I put it out there to you guys somewhere. on the community tab or something.
Mhm.
So Cher wants to know how many strikes do both
I know,
attorneys get, and
Cher.
that's a great question.
It is, and I knew somebody was going to ask me, and I didn't look it up. So I have to go to the statute and look it up, and I will do that. I'm so sorry. Somebody in chat probably knows. I should know, but I can't think of it off the top of my head. Carrie, I found the motion. Anytime you want me to talk about that.
Oh, you did. Okay. Yeah, go ahead because I
It
need
just
to
hasn't
go.
been ruled on. I mean, so the motion that hasn't been ruled on, the big one, the big deal,
The BSS?
is the BSS one. Yeah, from
So,
10-6.
well, I
He's
thought we
not
already had
ruled
the
on that.
motion. I thought we had we'd read the motion. Well, go ahead and
Well,
read
we
it
read
because
the no. That's what I'm saying. We've read the motion. My question was, did I miss him ruling on it, or there being a
oh,
hearing during my hurricane issues?
I got you. I got you. I
Because I'm
got
still this is a big issue, and I've been waiting for him to rule on this. This will change the trajectory of the trial immensely.
you.
So that
Okay.
was my question, and it was the state's motion in limine to exclude battered spouse syndrome evidence, or exclude mention of battered spouse syndrome evidence until the defendant testifies as to a justifiable use of deadly force. So we saw her get on the stand and testify, but the judge has not ruled, and that was my question. Had the judge ruled on this yet?
Okay. Hang on just a minute. I'll be right back.
Yana is saying that per law and crime, each side has 10 challenges they can use on Thursday. So, but they're for different purposes. You can, I'll find it, you guys. It may be a total of 10, but there's very specific reasons. Amber Rachel says, as Sam Kranick wants to avoid appeals at all costs. Oh, yes, he does. Feed those angry jurors. Yeah, jurors get fed. They have a very nice room, and they get fed. They get snacks and drinks, and they get all the nice things. It's just not common at a defense table. It depends on the judge how they run their courtroom. Like the last courtroom I was in, she had she even had sticky notes on our table, and like some little hard candies and things like that. Bama, I'm very sorry that you're going through what you are with your sister.
Oh, it's okay. I don't
My
know what's going on,
cookie.
but it's okay, Bama. Don't worry about us. You take care of you, Bama. I love you. Did you read this from Yana
Yeah,
while I
we
was
were
gone?
just talking about that,
Okay.
and I don't think they're wrong, but I do think there are specifics to it, and I need to look it up.
All right.
And I
Thank
will.
you,
I'm
Miss
just
Yana.
tired.
Thank you, Miss Yana. Oh, Yana brought up some images that I was going to show you guys.
Okay.
Let me see if I can. How do I bring them up? Let's see. I hate StreamYard. I really do. I really, really do. So here's Billy. I got to upload it. She sent these over. She said, "This is how we knew it was a different day because Sarah had on the same clothes."
Yeah, Billy didn't.
And yeah. And so
He
she's
told
like,
me
he had on a different tie, different everything.
he told me once that he has 3 weeks solid worth of suits, because he goes to where there's a trial and will be there the whole time.
And
I
then
do
the
that
other
too,
one.
but I do it here. I will have to travel out of my county, but
So then she put this one up.
yes, Bama, if you need it, you do not need to be here, honey. We love having you here, but if it's better for you not to be, or if you want to be here, it's completely
Don't
up
worry
to
about
you.
it. Yeah. Don't worry about us. We got this, honey. We're good.
Carol Bennett, what took place this morning? More jury selection. We're just sort of doing a check-in.
All right. Let's see. So that was the other pictures that Yana sent me. She goes, "This is how I know." Everybody was wearing something different. So I was like, "Okay, thank you, Yana. Thank you for that, Yana." And then she also sent me this funny one, but I gotta find it.
Yeah, Northwest. I hope tomorrow morning we will have something to watch. I hope. The judge is being very, 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 very careful here, as you guys are well aware. Well, Bama, then stick around because you know I'm going to say or do something stupid. And I'd be happy to take your mind off of it for a minute. This looks like Sarah with some blue hair there, Kiri. What you got going on?
Yana sent that over. Yana did a little bit of editing there. I'm like, you go, girl. You know what that reminds me of? It was like one of those sites where you go on and see what your hair looks like. You can change the color or the cut on it. That's what that looks like. I don't know where she got it from, but that's pretty cool. I was thinking, Christine, I was thinking that too. Are they all trying to match their outfits? I wanted to Google something about, is it common for defense teams to coordinate their outfits?
No.
Seriously.
I told you the story of in the most recent trial I had, there were 2 defendants. Our client, we worked with the family. They got him clothes, shoes, socks, belt, the whole 9. The other attorney was brought in at the last minute for the other defendant, and the defendant showed up in his jail uniform. And we're like, don't you have clothes for him? And he's like, no. And so the judge is like, well, you can go over to the public defender's office and see if they can loan you something because they have some pieces. And he came back with a full suit that fit him perfectly. But that's part of what we take into consideration. At least the attorneys that I work with, we take their attire into consideration, but we do not coordinate.
I was going to look to see if there's anything new from the media really quick that's been pulled up here in the last minute we've been on stream. They are talking about the Sarah Boone trial right now on Court TV, but they're not showing anything. Somebody's talking about cheating relationships with allegations. And the problem with me pulling it up, you guys, is because it's on their live thing. I can't rewind it, so we get into it midstream. So I'm going to go over here and see if I can't see what TV is doing. No, there's not anything. I don't.
So the issue I have,
I'm going to try to stay on top of just from media.
I just don't like it when they get attorneys in there that don't know anything about the case and then they're just speculating. It drives me insane. Heather Rosenblum says that Law and Crime already said they will stream the first half of the day as it covers all of the motions left on the table. Perfect. Then we will be here. We will be here. Thank you, Heather. Per Law and Crime. Yeah, Brad, courtroom attire is often a big topic, especially with celebrities. You're correct about that.
I'm sorry. Was I not talking? What happened?
No, you were muted. Oh, my circle is blank now. You don't exist anymore. My hostile takeover is complete.
Let me refresh.
Gen X gamer girl thought someone was doing her hair. Yeah, well, she asked for it. It was granted by the judge, but we don't see anything. Nana says you've seen trials where they've color coordinated. All right. In my experience, we have not done that. We just make sure we've got clothes, and sometimes that's a bigger issue than you'd think.
Okay. Sorry about that. I think it's my internet. You know what's weird? I'm trying to run my other computer, and when I'm doing that, it's like it's as if my other computer is slowing down this computer. Does that make sense Wi-Fi wise, you guys?
If you're on Wi-Fi, 100%, that makes sense to me.
Yep, and that's what's going on.
I hardwire whatever main computer I'm running at the time.
I'm going to close it out then.
I have hardwired in.
I'll close it out. Let's go back over here to Twitter. And I want to put this up in the background. So just we have this going on here so people know. At least we got it up. All right.
Oh, they're just rerunning that same clip over and over again?
Yeah. Well, I am.
Oh.
Oh, well, you know what? Let's move to the other one because this is a shorter one. I just thought that was funny how they were doing that. I think Owens is trying his hardest to
Why is, oh, I love this question. Brat X says, this is probably a stupid question, but why is Mr. Lane so nice to Sarah? Well, first of all, he's a nice guy in general. And I feel like he goes out of his way to assist attorneys and clients. And it's just in his nature, you know? He'll come out of the jail and have some things to say, but he won't be like that to her face. Although I do know they've had some more stern conversations. I am aware of that. But, you know, he's getting paid to be there. So, but he's got a lot of patience and he's nice.
Can y'all hear me okay?
Yes.
Okay. Let's see. I wanted to one thing I did look up, you guys, was I went into LinkedIn and I found something on Mr. J.
Oh, wow.
You know what? It could be somebody sent me this, though. Honestly, it's been so long since I've looked at it. I take that back. It could have been that somebody sent it to me because I remember being thankful when I saw it. Because I used to be on LinkedIn all the time, and I hate it now. I hate it now because I don't have to be on it anymore. Will J. He's assistant state attorney. He said, I served as assistant state attorney from 97 to 2007, leaving an advanced sex crimes prosecutor from 2008 until March of 2011. Pretty cool. After my first attempt in 2009, I became board certified in criminal trial law. In March of 2011, I returned to the state attorney's office as a career criminal lead trial attorney. And on August 1st of 2011, I was promoted to the homicide division. In January of 2003, I became the interim county court bureau chief. And on July the 13th, I became a trial unit director. In February of 2016, I returned to prosecuting homicides and other major crimes. And I tried to see if I could find Cacciatore, but I didn't see him on LinkedIn. But I like Jay.
Is he the one that's been writing the motions? Because I like whoever it was.
Yeah, he's the one with got a little bit of snark.
Yeah, love that. Love that. Mr. Owens has law students writing his, and Mr. J's over there pinning masterpieces.
Exactly. Like, and case by case. Here's the case law. Here's, you want to see that? Here it is right here.
Mm-hmm.
Because, yeah, it seems like that's an issue. I just wonder, does he have, like, I'm sure, is Margaret, other than working with him, she's got to have some kind of legal background. And then, you know, these consultants or whoever he's talking about, are they not doing research for him on his behalf? Isn't that what's supposed to happen?
Well, a secretary at his law firm, if he's got a secretary, they would not be. If he has a paralegal, then yes, it's possible, or a legal assistant, that's possible. But he's got these two young ladies, and so yes, I would think they would be doing research on their behalf. But
they work for Henderson. I don't think they work for him. They weren't hired by him. They were hired by Henderson.
He brought them.
I know, but they work for Henderson's law firm.
Okay. Well, one of them,
that was cool because I was like, okay, so I think James Owens is a one-man shop with Margaret. And I think that the reason he brought in all these other guys was because he didn't have the background. He doesn't have the staffing.
Well, one of the motions that came from Owens's camp was written by a law student, somebody who recently graduated or is in law school, because I recognize the formula. It's just textbook. It's what they teach. I spent a year teaching it during the pandemic. Somebody asked about how things were on my end. Tampa is getting back to normal. I got my power and internet back, not yesterday, but the night before, thank goodness. So I know that there's a lot of people who are hurting very badly. Chick-fil-A is not open. That was upsetting.
Oh, this doesn't have anything to do with. This has nothing to do with the Sarah Boone trial, but I need to show y'all something that I found last night that is just absolutely flippin' adorable. Okay, let me show y'all. I did the video. It's adorable, but it's not. Maybe I should change what I just said there. I'll change it.
Look at who we have there. Now, I don't know if this was taken last Monday or this Monday, because we know Sarah wore the same thing to court. But Judge, she don't get out of here till 9 p.m. at night. They wake her up at 2 a.m., Judge. You know, these guys are like two peas in a pod. You know what I mean? Two peas in a pod. They're made for each other. But you can tell by the body language, this man is not going to have anything to do with her after this trial is over. And can you blame him?
Found it before you called. Yes.
Are you claiming self-defense?
Yes.
Found it before you called. Yes.
Are you claiming self-defense?
Yes.
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 Yes. Okay. Let's see.
Mel says
I
the
thought
hand-
this was crazy, outrageous, and I had to share it with y'all. An 8-year-old Ohio girl who drove herself to Target. What? Okay, this article was published on October the 8th of 2024. Like I said, it happened in Ohio. It says that Zoe Wilson took her mother's 2020 Nissan Rogue out in the early morning hours of September the 15th. A neighbor's Ring camera captured the young girl getting behind the wheel and driving off. After Zoe and the car were reported missing, police officers eventually found the young girl inside a Target 10 miles away from her home in Bainbridge, where employees say she walked in ready to shop with over $400 in her pocket. Although the dash cam footage from another car on the road shows Zoe swerving in and out of lanes, fortunately, no one was injured in the incident. Zoe admitted to hitting a mailbox on her way to the store. However, she was not criminally charged due to her age. Police made the store give the money. It's not funny, but it is funny.
Year-old
That's
girl who drove her
crazy.
mom's car to Target went on a shopping spree. And a lot of us were going, how did this happen? How can an 8-year-old drive without getting in any type of accident? Here's how. Here's the first look at dash cam footage of her on the road. She's not that good. Police say she drove about 25 minutes before making it into the Target parking lot. I know. It was early enough, it looks like, that there weren't a lot of people on the road. She's weaving in and out of lanes. She did admit she struck a mailbox during the ride. I mean, thank goodness it was just a mailbox. Target employees say she spent $400, Greg, shopping around, checked out. She also made a stop at Starbucks to get a Frappuccino.
I mean, running red lights, maybe.
We're all okay. So we're all, we've been talking about this, and I'm sure being very judgmental. But I mean, we all think that she's probably driven before. That's why she was able to do as well as she did. How long do you think she's grounded for? Please tell me.
At least until high school graduation.
Like, we're saying ha, but if I were her parents, I'd be like, you kidding me? You could have gotten yourself killed. And somebody else.
Yeah.
Look at that little thing, you guys. Look at this little thing. See, these little criminals, they come in all shapes and sizes. We got to watch out for this one. Yeah, somebody mark that name down. You never know what's going to happen when she gets older. I'm totally kidding, by the way. She probably didn't think nothing of it, but I think that's hilarious. She had $400 in her pocket. What you bet this little girl ends up owning her own company one day? She's an entrepreneur. She gets things done. She doesn't wait around for mom. She's like, I don't have time. Just give me the keys, woman. I don't have time for this. She's precious. And she's cute. It's not funny, but it's funny. You know what I mean?
She's like, Mom, just give me the keys. Just give me the damn keys, woman.
That's so funny. I wonder what part of Ohio that is, because in more rural areas, I'm sure this is true across the country, we all learned how to drive way early. You learn how to drive like on tractors and stuff, and then farm trucks. But that was pretty brave. 25 minutes. That's amazing.
I think I learned mostly on we had motorcycles and stuff like that, or four-wheelers or well, we all had three-wheelers at the time I was growing up. We didn't have four-wheelers. They were just coming out.
Yeah, I had a
And
four-wheeler.
anybody that had a four-wheeler in our neighborhood were considered to be like big time because they had a four-wheeler. You know what I mean?
My dad got me and my brother one for out at the farm.
But
My mother
now
was thrilled.
now that everybody has side-by-sides and all those. and
Yeah, all kinds of things.
those are cool though. They really are cool. But they're a kid. The side-by-sides can be a little bit hard to maneuver for a kid. But anyway, yeah, I just thought that was really cute. I wanted to see what the chat said about it. Because I've been in and out having to try to put this stuff up, and I don't know what Sam's put up. I want to go through this really quick. Did we talk about Zombie? Thank you so much for your super chat. Kranick probably asked about their biggest fear due to claustrophobia and the suitcase. You know what? That's a really good point, and I
That's
think
what
you're
I said.
probably right. Yeah, I didn't know if I don't remember if we went over this. I've kind of been out of control here. 12. We did Blanco. We got Matt. Did we talk about? Oh, thank you, Marlene, for becoming a new member. And did you ask about Jet Set, where he said that I thought they were talking about medical records? Did you answer their question?
No, I didn't see that.
Jet Set said, I thought that the motion was for medical records. And I said, and he says, and someone's saying that it's her medical records, not his. And what I just read, it sounded like his medical records. It's definitely talking about his medical record.
Yeah, the motions language is about him. His from incidences that don't have anything to do with her.
Bama, honey, don't worry about this stream, sweetie. Go do what you got to do. We love you. Just go take care of your family.
Yeah, for sure, Bama.
I'm so sorry, honey.
All of chat is with you.
We love you. Praying for you. Another person we need to pray for is Lenny. Lenny's having knee surgery tomorrow, and Laura was talking to Lenny about the knee surgery, and she told Laura, she said, "Well, what did I miss on Carrie's stream?" She's like, "Don't worry about that. You got to worry about." She goes, "No, I'm afraid I'm gonna miss something."
Oh my gosh, that's so funny.
While she's sitting up there trying to heal herself, she'll have something to watch for sure with the trial coming up here. Let me check. Sam, if you want to interact with some of the members on chat, I'm going to look over here and see if I see any updates on Twitter. It's been a while since I checked.
Well, chat was talking about cheese earlier.
Oh, God.
Yeah. Now they're talking about Sarah's outfit. Nobody really had any questions today. One person asked about how the hurricane was here. I think I said we're healing, getting better. Yeah, you guys are just having your own conversation over there.
This is some guy on Twitter had said something about, let's not lose sight. Excuse me, I'm so sorry. Let's not lose sight of the fact that there was a man brutally tortured and suffocated to death, and his loved ones that need to be remembered. Yep, absolutely.
100%. When Train is asking, why is Sarah in the courtroom today? Because she's a defendant. She gets to participate and is required to participate in all of it. That's why Daryl Brooks kept getting moved to that second courtroom so he could still participate, but I guess not talk over the judge.
So Kathy Rusin on Law and Order says that there are still several motions to argue, and that's going to happen tomorrow morning. We will live stream it. Good. Finally. Wednesday afternoon, the state will conduct individual how do you say that?
Voir dire.
Voir dire. Why can't I? It doesn't look the way it sounds. Voir dire. Oh my gosh. So Wednesday afternoon, the state will conduct individual voir dire. Thursday morning, the defense will. And therefore, openings will not be until Thursday afternoon, you guys.
Wow. So we're looking at a 3-week. We're looking at a 3-week trial. So Mary Jo, no, I haven't listened to it, nor do I want to, honestly, because I'll never stop thinking about it forever. But I'm glad you guys got a chuckle out of it, or a big laugh. Somebody just asked a question that I wanted to answer. Where did you go? No, I don't think Sarah will have to be removed or gagged.
So Kathy said that each side has 10 preparatory challenges, which they expected to use on Thursday.
Mhm.
And
So here it is. Sue Parker says, will we not see jury selection? It does not seem as though the judge is allowing that.
yeah, they're not letting them stream.
No.
Not while the jury's in the room. That's why, like, the stuff that you guys might see here, like with them back and forth and everything, that's the morning when she's coming in and getting situated. By the afternoon, though, and when the jury starts, because I think the jury comes in around 9:30ish, or the
8:30 to be up there by 9. He starts at 9.
Yeah, so we're not going to see, and he's being safe. He's trying to be better safe than sorry type thing, which I totally get. Let me see if there's any more updates from anybody else. I want to thank you guys, by the way, for being here as we go through these. I mean, there's not a whole lot we can do, but just try to stay up to par on this. Yeah, just try to keep you guys up to date, and that's
the motions hearing is going to be important, really, really, really important. Tomorrow, they're saying that's tomorrow morning. I hope that's true. I want to see that very badly. We are not. I just don't think we're going to see any jury selection.
Judge saying right now there's pool of 43. This is from 14 minutes ago. Judge saying right now there's a pool of 43 potential jurors. Judge suggested jury selection could be over tomorrow. State drops mini bombshell that they just received the 550 pages of Sarah Boone's medical records. Sounds like state has filed motion in limine. Also sounds like, which we know about, also sounds like it could be Thursday for openings at the earliest. So that's just another person that's in there. Let's see what else. That's coming from Surviving the Survivor. And then each side has 10 we already read that. This one girl, I hate saying that word. I'm not good at it, I guess. The one girl that's from Fox 35, she's not reporting very much on Twitter. She's not keeping us updated like I'd like. So
why is it not Wish that is reporting? I know one of the reporters from there. He's covering
that's
another
a good
one of
point.
my cases.
I like Wish because they were on top of stuff earlier, but I haven't seen them either. What I would like to play for you guys now, let me just look at my checklist.
Zephyr Sky, thank you for being a member for 14 months. Think of George. He passed out for his family.
Thanks, Zeph.
George, and pray. He passed out. Pray for his family. Thank you. Thanks for being a member.
Zeph is always so kind. Did you already do Kathy's?
I'm sorry. You click, I'll move.
Looks like
no,
she's wearing a Halloween costume, dressed up as a normal and sane person trying nice, but Kathy, that is hers. That's her Halloween costume.
Thank you for your super chat, Kathy.
Thank you, darling. And then
Tracy Clifford, thank you for becoming a new member.
Yes, thank you, Tracy. All right, Instagram video that Sean sent me. I was going to play that eventually. Sean, I have not forgotten your Instagram video. Let's see. I've got something I wanted to play here. Let me pull it up. And then I think we might call it because it doesn't look like we're going to get a whole lot today. Not at least not what I was hoping we would.
Northwest is asking, why isn't the defense filed a response to the state motion in limine for battered spouse syndrome? I think that's a good question, and I don't know the answer. I didn't realize how tired I was. Oh my gosh.
Legal. Okay. do you guys want to look at?
Oh,
I've got
this
an
is
evidence.
nice.
Let's do the evidence review. Let's watch. That's 2 hours long though.
Simi for Life says, I just love spending time with you in Florida PIC. It makes my workday better. So glad we can help you.
Aw.
I'm avoiding my workday. Don't tell anybody.
I think this is everything we've got right now.
Yeah, I think so.
I could show you guys if you want to let me look at the chat really quick. I feel like I'm not getting to everybody the way I'd like to, so I apologize. Let me go back through and just thank everybody again for all of their Matt, thank you for your super chats. I know you did several. Thank you, Blanco, for being here and for 12 months and putting up with me and putting up with Mark too. I appreciate that, Blanco. You know what I mean. And thank you, Marlene Axe, for becoming a member. And again, Kathy, thank you so much for your kind super chat. It's so appreciated. And Zeph has been around for a long time. Thank you, Mama. And again, Tracy, welcome to the Crazy Club. I hope you don't regret being here.
Right.
We hope you don't regret being here. All
We
right, I'm going to take a moment to go in and read my chat a little bit. Let's see.
I was just going to say, Carrie, they keep asking us to remove banners so they can see Sarah better. When there's more to see, we will clear the screen so you guys have a full-on view of Sarah. But as you can see right now, we have the edge of the box. You can't see below the table. So we'll make sure you have a clear view. Sally Bragg says, I can't find how to become a member. One of our fantastic mods will help you through that, or maybe somebody in chat. Crazy KC, where you been? I haven't seen you in a minute. Best chat ever. It is a great chat.
What did Amber say? She totes asked for water just to exert a modicum of control to make herself feel better. I know. That's what I'm saying. It's like it is. It's like she has to bark orders or something. It's so odd. It's so odd. Her hair is giving Kate Goslin. She wished she looked like Kate Goslin.
Have we ever seen The Third Attorney?
If it's Kevin Beck, it might be that older guy that I kept seeing a picture of from last night when she was leaving.
Oh, okay.
That if you watch the video that I did last night of the update from yesterday, it's really short. It's an older gentleman, and it looks like he's sitting back where this other consultant is, and he does have a briefcase with him. So I'm assuming that's Kevin Beck, but I'm not positive. What time is tomorrow? Being in the UK, I need to work out my times. Okay, so tomorrow. Oh, thank you, Emmy. Tomorrow is, I don't know. I like the idea of going live at 11:30 in the afternoon tomorrow because we're still sitting here. Well, no. I take that back.
No, there's going to be stuff.
They're going to be meeting in the morning. Yeah. So I'll probably go live in the morning between 7 and 8 a.m. Central Standard Time. I want to look at what time the judge puts up here for his time there and just double check. And so we'll go live on that and make sure we're here. It's not on from what I see, it's not on the docket yet, but.
Laura says Casey's been here the whole time. I'm tired today, Laura. Sorry, Casey. Nice to see you.
Brad, I can't believe her. She pointed about the judge about him not getting it. Well, you know what's funny about this, Brad, is I was rereading the letter that she did complaining about, it's my docket dive. That's what I was going to play for you guys this afternoon, my docket dive. I was rereading the letter where he put her as pro se. He ordered her to be pro se. And she said that, he said that, you ask for somebody to communicate with you. Now they're communicating with you, but you don't like the way you're communicating with you. He's like, he just keeps going and keeps going and keeps going. Wait, did we get another super chat?
No, Mel just posted a joke in there.
Oh.
Hold on. Somebody said
No, we
something.
did get a new one.
Sam, every time you say I'm sorry, please post something on your YouTube channel. How did you know I was looking at my YouTube channel yesterday with no content? I have 5 subscribers.
Business sexy.
Yeah.
I like that, Kathy. I like business sexy. That's nice.
Yeah, Laura, I know. I deserve the crap. It's like the adrenaline kind of drains out of you and then you're just tired. Like when the air conditioning comes back on, it's joy and then sleep. And then you wake up and you're like, I can't function. I'm so tired.
I'm trying to see what Leah. Y'all are so funny. Y'all talk back and forth, and I can't see if y'all are. Does anyone know how I changed my membership? Okay, how you change your membership emoji? You can't, Cheryl. It's your membership emoji is based upon the amount of time that you've been. So, like, oh, you've probably. Do you have? I can't see it on StreamYard, but I bet you have. What's his name? You have Owens right now, don't you? Yes, that's the hell that you're in for the first month as a member. I do apologize. Maybe I should change it to Margaret. That might be a better idea.
LW says, I don't know if you already answered this, but what is Billy's job supposed to be focused on while he's sitting there? Billy is running his agency, but he is also doing background looking up on potential jurors. He helps. I mean, I'm at trial too, so I also help with jury selection and all the things. So Billy is just sort of supporting and researching, and if any of the witnesses that the defense needs are in the wind, he will go find them. That kind of thing.
Weedhopper says, does she have a top on underneath that green shirt? I think she's got like a little tank thing underneath it.
Yeah, it looks like she has a cami.
It looks like it probably goes together. It might be one of those that's like a faux cami, underneath. It said at Janice. Oh yeah, Janice, we read the motions earlier, honey. They're talking about his medical records. So let me catch everybody up real quick. So they're talking about his medical records, and in the motion, the state is saying, we just got these. They've had them since, what was it, January 2022, and we're just now getting them. And you're wanting to throw this 550-page document of medical records at us at the last minute. And there was some talk in there about when George had surgery because he got into a fight with one of his brothers. And there was another discussion about him putting his fist through a window where he got cut. And I think what the state's trying to do is avoid it, making it look like George is this aggressive person that likes to fight. And so they're like, they don't even want to argue with what they're going to allow in and what they're not going to allow in. They're saying, nope, we don't want any of it in. So I think probably what they're going to be doing is they're forcing the defense to come back and say, well, we got to at least see what his medical records are for, the last year or whatever. So I kind of felt like that was a play that the state did to just say, we know he's going to come back and we know he's going to want to show that possibly. But yeah, I don't think they're going to be able to find that there was anything wrong with George, though, other than the fact that he was an alcoholic. I don't know what else.
I'm real interested to see what Owens's argument is on that, because I guess it's going to be that he had underlying health conditions. As someone in chat said, you guys are very smart. I agree.
Sarah had said he had underlying health conditions.
Yeah,
but we haven't seen his medical records.
Right.
So how do we know? Like, she's such a liar,
Jury selection will continue tomorrow, Hubgrass. We are getting information that there will be a live stream in the morning of a hearing to settle some of these outstanding motions. And trial begins what day? Thursday?
They're talking about trial maybe Thursday afternoon starting. So we'll be live tomorrow morning. Here's what I'm going to tell you. I'm going to be live tomorrow morning to see if they're going to do this hearing. And then we're just going to have to take it day by day until we know what's going on. Right. That's probably the easiest way to say. If you're trying to plan your time out, they're saying that it could be opening statements may not start until Thursday afternoon. So just if you're trying to do that. Mel said, why did Sarah Boone cross the road? So she could get home after the bar closed. Wah, ha, 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 ha. I love that. All right, let's see. Tracy, I think Rigger has... Oh, Tracy. Hang on, I'm going through them.
Allegedly, she has a green undershirt on. It's a look, Northwest said. Janice. All right, you guys. Well, I'm going to play this docket dive, it's from the fourth piece in my docket dive. I'm going to close out with this. It's the fourth piece in the docket dive, and it is, it's not too long. I forget how long it is. It's not that long, but it will keep you guys updated on what happened when Cashman was involved in the case. And it finishes off the docket dive that I started and never finished because I got sidetracked because James Owens came on the case. Let me see if I have it here.
Yes, please hit the like on your way out. Thank you for being here.
Here it is. All righty. Let's get to it. I'm going to go on mute. Docket dive series a little bit further back. And there's 4 pieces to this. This is the 4th and final piece right here. And this is the part where you guys can finish up if you've been watching it. Look, it wasn't one of those things where people were like majorly in demand of it, but I think it's important because we get to look at every piece that's in there and we get to analyze. And we always pull out little interesting tidbits in doing this. And because I am the way that I am, which some of you guys like, some it drives you crazy, it just helps me see things clearer. So I guess in essence, I'm doing it for myself more than I am for you. That's not true. That's not true. That's a lie. So here's what I thought we'd do. I've been meaning to do it. I've needed to do it. We're going to finish our docket dive. Okay, where we ended the last time. We ended with Winston Hobson requesting to come off, and the judge gracefully said, I get it, man. I'm going to give you a pass on this one. But remember, you owe me one. And then as Hobson was running out of the courtroom, he pulls his cell phone out of his pocket and he calls his friend Kyle and goes, Kyle, it's done, dude. Meet me for a drink. It's time to have a cold one. And then you hear Cranick in the background going, take me with you. Get me away from this person. Oh, I can't rotate out fast enough. Poor Cranick. You know, if you think about it, you guys, think about how Cranick got into this case. They rotate every 2 years, I think is what it was. I'm not sure if that's it, but it's a rotation thing, right? So it's just like chance that he got. The Lord works in mysterious ways. I do believe he's a great judge for this case. I just feel bad for him that he has to deal with first Sarah Boone and now he's having to deal with Owens. But I'm sure he's dealt with worse than Owens. Owens ain't nothing to swat a fly at. But I just kind of feel like, what are the odds? I wonder if he's ever sat around after a long, hard day dealing with this case and gone home and sat there and, I don't know, maybe he's just in the car driving home and he thinks, what are the odds that I would get this case? What are the odds? All right, so let's go into the next greatest thing I'm going to share with you all, the docket, the infamous docket of Sarah Boone. I am not going to be sad to see this docket go when this case is over. I just want to let you guys know that. So he put the motion to withdraw in on the 1st of February. So the 9th was when they let him off the hook there. And then appointed on February the 9th, Patricia Ann Cashman, Esquire. I think you guys have all seen those photos of Miss Patricia. Didn't they at one point say that they had brought her in on this case because she's dealt with a lot of people that are difficult? I think that's how it was worded. Difficult. That is one way to describe Sarah Boone. Difficult. Now that I know the docket much better than I did the first time we went through these things, I might be going through them a little bit faster. So here we go. Next item on the docket. It's a notice on the Brady. The Chelsea Copsell thing. The state had to give notice that she had a Brady violation charged against her. Nothing happened. Nothing occurred on it. It's one of those things to where the witness said that she was saying things that the witness didn't say. She was reading things to on her report that didn't happen. And also that it might even have been
reading Miranda rights. But anyway, it was, regardless, it doesn't matter because it was investigated and nothing happened. It was thrown out. I've heard from other people that a lot of times defense attorneys will pull something like this, especially if you've got somebody who they don't have a lot to work with, maybe a defendant that's, well, you know, like Sarah Boone. There's not a lot to work with. You got a guilty person here and they look guilty. Now, I'm going to let you guys know in advance. Patricia came in and got some stuff done, okay? So it might take me a little bit longer to do this video than I thought it would. She respectfully demands all discovery required or authorized, and further demands that the defense counsel be permitted to inspect, copy, test, and photograph said discovery. Court order. What they did was they moved the next status hearing to April the 12th of 2024. And it just says that the defense motion to withdraw was granted, and the court appointed Patricia Cashman. And here we have 5 filings from Cashman for motions for costs. Let's see what she's asking for. Now, this is where I think it's interesting because I just want to see who she's bringing in, who she's going to use, if she's going to continue to move forward, where her angle was on the defense. So she was asking for transcripts from the CSIs that were on scene that day. She wants all of their depositions transcribed, and she's just asking for the JAC to pay for all that to do that. The other one motion for costs is Dr. Zadowicz and Diane Johnson Carwise. Depositions of Dr. and Diane Johnson Carwise taken on May 3rd. Guys, I want to know who this Diane Johnson Carwise is. And is Carwise her last name, or is that where she worked? You know what I mean? Because there literally was, what do you call it? There was a body shop not far from them called Carwise. So I automatically assumed that this lady worked there. And I assumed that it had something to do with detailed work on Sarah's car after she hit somebody on a bike, because that was said in Juan's testimony, George's brother. But then somebody made a good point that, well, I don't know, maybe George worked there at some point. Maybe Sarah worked there at some point. I was like, okay, good point. Maybe. Anyway, that person's deposition was taken. I think that person is going to be on the witness, and I would love to know who they are and what they have on this. This particular motion right here is just asking for the cost to transcribe their deposition. Okay, next one. Oh, now she wants the transcripts for Juan Torrez, Vincent Battaglia. So they did depose him, and they deposed Brandon Motes. That's interesting to me because I did not think that we knew that there was an interview with these guys, but we didn't realize that they had been deposed. I knew they were going to depose Juan. So anyway, again, she's asking for transcript costs. So this is good to know. This is good to know because this is giving us more information about the case that I wasn't aware of, because I stopped my research midway. In the middle of doing this and that was when they assigned Owens, and it shook everybody's world. And I was like, oh my God, I totally got sidetracked. Okay, so here they're just asking for the JAC for a psychologist and move towards the expertise in battered woman syndrome. Then notice of filing. Hereby the files the email. The Justice Administration Commission has requested the undersigned counsel attach this email to the motion for authorization of costs for a psychologist. That's all that is. Like I said, we're probably going to move through these pretty fast. Again, another JA item that she needs to attach, and another. So they got 3 different motions here for the JA is requiring, so that they can pay for whatever happens, whatever she needs there. Then we come into a motion for order on motion for authorization to incur costs to obtain copies of transcripts of depositions, and the judge signs off on it. Thank you, Judge. Thank you, Judge. And then he signs off again and then he signs off again on the next one on the list. And then, oh, one more. He signs off on the psychologist fees. One thing I will say though, I mean, Judge was getting she was getting these in, and Judge was responding to them pretty dang quick. Well, he knew he had to, I guess, but Okay, now here's the interesting stuff. She talks about who she wants to depose. Of course, the first people that she wants to depose is Detective Copsell and Detective Lowen. So she's already got it scheduled, and here's the notice to the court of the schedule of it. Okay. Amended order or a motion for authorization to incur costs. Okay, so this is another one that judge had to sign off on. This is for Dr. Zadowicz. I think, y'all, if I'm not mistaken, let me grab my notes. I do believe that doctor was already on the list. I'm going to go back to my notes from when I first started doing this, which is way back when. I have gone through, you know, these notebooks that have they're like the kid notebooks. How many pages does this have in it? 70 sheet. I've already gone through 3 of these for her trial. Keeping myself sane. Trying to keep myself sane in all of my note taking. I know these days people don't do this anymore. People put it on the computer, but I like to write sometimes. I just enjoy writing with a pen. Don't you guys say anything about that. So yeah, I like to write some of this stuff out sometimes. But then when I go to find it, I can never find it. I guess I could scan it. I don't see her name though. I don't know why I say her. I figure this Dr. Z is a woman, but it could be a man. Actually, they mentioned Dr. Wiley or Willie. But I'm telling you guys, I've seen Dr. Z before. Doesn't matter, I guess. Not a big deal. Order to transcribe. Michael J. Kranick. You get a transcription. You get a transcription. And you get a transcription. Yeah, I'm just kidding. No, he did several orders on those. They set a hearing for April the 12th, and here are the minutes from it. And we probably have this on video. I just don't remember exactly which hearing was which. So they determined the new trial dates, and they said that she has hired experts and has outstanding depositions scheduled. Okay. Status hearing to set determined trial dates. So they picked the date of June the 7th for a status hearing. Not that that matters because we know it changed. Order on motion. Judge allowed her to all the JAC stuff she needed. He handed it over to her. Notice of removal of a state's witness. Well, what happened here? Oh, from the Brady. Okay. See, this is what I was talking about. She got exonerated. So they found that there was an issue in the Orange County Sheriff's Office administration investigation into falsification of records. And she was exonerated. So, okay, now I understand how that works. Because I was thinking, why? So every time she has a case, they have to notify. But apparently it was brought up while this case was still ongoing. And now it's been taken care of. I bet they have to take care of that stuff fast, too. I bet it happens all the time. So, yeah, Copsell was exonerated from that. So that's just them putting that in. But they had a hearing on June the 7th. And at this hearing, they scheduled the trial management conference for September the 4th and the trial for October the 7th. So here we are. This was the first time. And just so you guys know, this is June 7th of 2024. This is when it stuck. This was the first mention of the trial dates that we know happened, except for the fact, except for the fact that September 24th got changed to September 26th for the trial conference management. And then, October 7th got moved back a week to October 14th because of the hurricane. But otherwise, it was the same exact date, okay? So the defendant advised the court of her concerns with her attorney. So this is where she first goes in. This is the infamous court hearing, you guys, where she talks, and then Cashman comes back and she's like, she just needs to be nice to me. She's not being nice enough to me. And then Cashman comes back and says, Your Honor, she's walked out of our meetings. I don't know how I'm supposed to do this. And of course, the defendant provided the court with a letter in open court. It says Attorney Cashman addressed the defendant's concerns with the court. It says the court took under advisement and will readdress prior to trial. The defendant provided the court with a letter in open court. I think this was when That was on the 7th, right? I think she sees this document here. I know. I think I've read this. I think I've read this next document. Because I think I remember thinking, she saw this letter and she's like, that's it, I'm out. I'm out. Because on the 11th, and maybe it was the way Sarah was acting in court. I think it was a combo, though. I think it had to do with the letter. We're going to look at the letter in a minute. Here's what Cashman's motion to withdraw said. As grounds, therefore, defense counsel would state as follows. The defendant is charged in the above style cause for second-degree murder. The undersigned counsel was appointed to represent Sarah Boone on February the 9th of 2024. Trial is currently set for October the 7th, which will allow new counsel time to prepare for said trial. Yeah, remember when we went over this, you guys? I remember reading this. A normal person would want their attorney to like them, to fight hard for them. Why? Why does she need to be so difficult with everybody? So she stated again, irreconcilable differences, including but not limited to ethical considerations, have arisen such that the counsel can no longer provide representation. God bless her. And she said, peace out. And that was on June the 11th. Oh, shoot. I did it again. I wasn't sharing the tab. Sorry, y'all. Oh, that's right. That's right. The letter, the infamous letter, is the 58-page letter that went with this. It's all coming back to me now. Isn't there a song by Celine Dion that says that? All coming back to me now. Yeah. This is the 58-page letter. And I said back then, when this happened in June, I said, guys, viewers, it's not just what she did in court. I'm telling you, she read that letter and said, ma'am, bye. It's not happening. No, no, and no. Then, of course, we've got the 58-page letter. I'm not going to read it. I have a whole video that is dedicated to this stupid 58-page letter that I will link or attach to the back of this video here. And then, of course, Kranick said, Patricia, don't do it to me. Why don't you sleep on it? He said, Patricia, will you sleep on it? Please don't. And she said, you don't understand. And he's going to say, oh, I do. I just was hoping you'd be okay with it. He said, okay, you can withdraw. But the best part about her withdrawing is that that's when Cashman clapped back with that great letter to Sarah Boone saying, ma'am, you are now pro se. No, we're not talking. No, ma'am, you're not talking. Stop talking. Stop talking. Sit down and listen. And let me tell you what's going to happen from here on out. If you want to get out of jail, you need to listen to me. You've got so many rights, but I got so many limits. Your rights don't overexceed my limits, okay? Let me read what he says here about her withdrawing. Is this the one where he tells her she's going pro se? I think this is the one. Yeah, we're reading this. Okay. Yeah, this is the one. Because he said, I'm going to let you withdraw, but you're not just withdrawing. Sit down, shut up, and listen. This is what we're doing. He's like, Patricia, save me a bar stool. I'll be there in a little bit. He says, on March 23rd, 2020, by way of information, the defendant was charged with second-degree murder. On February 20th of 2020, the Office of the Public Defender's 9th Judicial Circuit in and for Orange County, Florida, was appointed to represent defendant. On March the 9th, the public defender withdrew due to defendant retaining private counsel, to wit, Mauricio Padilla, Esquire, and the Padilla Law Group. On March 11th, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. Okay, so that was March 11th of 2020. On April the 18th of 2022, so just over 2 years later, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court at the same time, maintaining all duties to the client. Y'all, that piece right there is so, it's like code for this bitch is crazy. That's what that code is for, y'all. Seriously, in the legal world, like we don't know, but what we do now, like now that the Sarah Boone case has come along, we in the outside world, outside from attorneys, we know now, but we didn't know that before. The motion was served upon the defendant, and the defendant confirmed receipt. I bet she wishes she could go back and get Padilla. I think that she was pushing her limits with Padilla, but I also, there's no telling what he put up with before he withdrew, if he was there for 2 years. But I can tell you that I think he did a lot on her case, and I don't know exactly what it was that happened. If it might just been an accumulation of things, and he just said, "This is it, I'm done." But when that happened, she didn't learn anything new from it, obviously. On April 29th of 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing the defendant for 2 years. The defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant. This was the first letter she wrote, I believe, where she says, "I didn't even know he was withdrawing. I found out he was withdrawing when I was told to come to court." A letter dated April the 20th and filed on April the 26th, which seemingly objected to his withdrawal. Exactly, see? The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address those irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw. They gave him until May the 3rd, but remember, it didn't take him until then, to prepare and file an amended motion with a hearing to be heard the following week on May 9th. The state advised of Padilla's diligence and preparation, and the court commended him on his work. The defendant testified to a lack of trust between herself and Padilla. Little did she know. On May 24th of 2022, Padilla filed an amended motion to withdraw. And here he said that the undersigned's relationship with the defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. The undersigned appreciates the court's providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. That's so key, you guys. It's like it's so bad that I can't even tell you what it is. And Wooten, because Wooten was on it at the time, Judge Wooten, he was like, "Come on, just tell me what happened." And Padilla said, "Yeah, no. I like my law license. I worked too hard for it. I have my own practice that I'm proud of. And this woman is not bringing us down. She's not bringing us down." And then on May the 6th of 2022, Padilla filed a second amended motion to withdraw. And he said, undersigned relationship with the defendant has deteriorated to the point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with the with the rules and regulations of the bar. They're present, and whether the attorney-client relationship has deteriorated to a point where counsel can know. He references a ruling under the Florida bar about attorney-client relationships being deteriorated. And on May 10th, a hearing was held on his second amended motion to withdraw. The defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. See, that is right there. Ethical. That makes me go, I mean, we could wonder all day about what she wanted. Maybe we should have a live stream. Salacious speculations. What concern did each one have specifically? What did Sarah do specifically to that attorney to make them withdraw? So the defendant confirmed that she wanted to terminate Padilla as her attorney. Oh, she's like, you can't quit because I fire you. And then the state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The state then expressed a concern of a strategy to allow defense attorney after attorney to represent the defendant. The court advised the defendant of the state's concern regarding the strategy of defendant being unhappy with every attorney and advised the defendant about the dangers of self-representation. And then the court appointed public defender number 3. So even at that point, you guys, in May of 2022, because technically when you think about it, Padilla was really her first lawyer. He was really, because the other guy was in there like a day and Padilla came in and was like, I got this. He flew in with his Batman cape and was like, I got this. I'm going to represent her. And I think he had good intentions. I also think he was in it for the clout and everything. But he did a lot. He did a lot in those 2 years. So then he went back to his phone booth and he changed back into Clark Kent and said, I'm out. Word to your mother. I'm gone. All right. So then they did the third one. Now the third one is a conflict. It was like, okay, I'm just going to read this. On June 6th of 2022, the public defender moved to withdraw due to a conflict, which was not at Sarah's fault or anything. It was, I want to say one of them had represented, and I can't keep them all straight at this point, but you had 2 or 3 of them that had represented either her or George in a previous case. And then one of them had represented the apartment manager in one of her cases where she had a DV thing that she charged somebody with. So yeah, there was a true conflict. So then on June the 7th of 2022, that certain order allowing public defender to withdraw was entered, which withdrew the public defender from further representation of the defendant. And they appointed the Office of Criminal Conflict and Civil Okay, they did all they needed to do. Then on June 10th, RCC moved to withdraw due to a conflict. So they went to Regional Counsel, RCC. The defendant appointed the Office of Criminal Conflict and Civil Regional Counsel, RCC, and attorney number 4. That certain order allowed the Office of Criminal Conflict and Civil Regional Counsel to withdraw was entered. I don't understand that part. RCC. RCC is the Office of Criminal Conflict and Civil Regional Counsel. I'm not really sure. Sorry, guys. I'm not an attorney. So then on June 22nd of 2022, they appointed Mark Consalo, and he was considered to be attorney number 5. He had to withdraw because of one of the conflicts. Okay. So he was out, didn't even, within a day he was gone. Then they appointed Bankowitz on July the 11th of 2022 after Consalo withdrew. And it says on July 12th of 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted. Thereafter, the court set a pretrial conference for October the 25th. On October the 25th, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to all parties to confirm if continuance was being sought. Okay. They asked for a continuance on October the 27th. They were granted it on October the 28th, and they moved the everything forward to a pretrial conference on January the 17th of 2023 and a trial starting on January 30th of 2023. Then November 22nd of 2022, 11/22/22, the court set a status hearing for December. The day before the status hearing, on December 19th of 2022, Bankowitz moved to withdraw due to irreconcilable differences which have arisen between the undersigned client and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. I still don't understand why he said his family there. I just think that was weird. And then on December 20th, maybe it's not weird, maybe I just don't understand it. On December 20th, the status hearing was held, and Bankowitz did not appear due to a car accident that he'd been in. And so they reset the hearing to December the 22nd. And then it was like, Merry Christmas, Sarah. You ain't got no attorney. She got coal in her stocking. She had her RT ripped away from her for Christmas 2022. So then they moved it back to a status hearing for the 27th. They held another hearing. and Bankowitz's motion to withdraw, and he was present for the hearing and was sworn, and the court advised, and this is a very, very well watched hearing that you guys could probably remember half of what they said. And it just says that the court advised the defendant that the court had received the letters from the defendant, a letter dated October the 3rd and filed on October the 7th, a letter dated November the 3rd, and a letter dated December the 5th. The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Ugh, God. Let him go. Let it go. Poor guy. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla had utilized. Bankowitz advised that the court of the defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day, and that's just with limited phone access. Bankowitz further advised of his client's efforts to balance the demands of other clients. So she wanted him to stop everything he was doing and work on just her stuff. And remember, he said in trial that he had like a big murder charge case that he was on, had been on for quite some time, and that was coming to an end. And then I think that was the case also where the prosecutor had lost his spouse, so the case got pushed back, and so they were going to have a hard time rescheduling that case. I mean, he did come in with a lot of excuses. I mean, he got COVID, he got in a car accident, he's got a case he can't get out of. Unfortunately, I mean, I don't know if the guy just has bad luck or if he dwells on the negative. I'm not sure. But those are all things that did happen to him. So the judge said, all right. They continued the case several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to the same. During this time, the court had received several letters from the defendant. Jesus. On August the 22nd, Bankowitz moved. So he talked him into staying with her. And then on August the 22nd, he came back and said, no, I can't. So Bankowitz again moved to withdraw. Irreconcilable differences between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. Except he says that, and then he goes on to say this. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Miss Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Well, Court TV, all the media got a hold of that and just went haywire with it. He should have never said that. But in his defense, she did call him a buffoon. I mean, among other things. So on September the 8th of 2023, a hearing was held on Bankowitz's motion to withdraw, and the defendant was present for the hearing and sworn. And Bankowitz addressed the defendant's derogatory statements and the berating behavior. The court advised the defendant that the court had received the letters from the defendant. And he even told her, he said, I read your letters. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson, attorney number 7. They need to write a song about this. I think they did. It's called Mambo number 5. I think I'm saying the last docket dive. Therefore, the court set a status conference for October the 30th of 2023. After setting these dates, the court pointed out the deterioration of the work relationship between the defendant and Bankowitz. He gave her he was pretty matter of fact, Wooten was, the Judge Wooten that was on this at the time. He just straight out told her, you can't continue to do this. She has unrealistic expectations, that she cannot make demands of her attorneys, that she is dealing with court-appointed attorneys. She's not dealing with a paid attorney. There is a difference. Then on October the 30th, status conference was held, and Hobson advised as to his conversation with the defendants and set a status in January of 2024. So that's when the court dates were moved to. On January the 12th, he filed a motion to continue. On January the 16th, they addressed that motion to continue, and then they granted him a pretrial conference for May the 3rd with a May the 13th court date. And then on February the 1st of 2024, Mr. Winston Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. On February the 9th, a hearing was held on Mr. Hobson's motion to withdraw. And Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. She's trying to tell him how to do his job, and she doesn't even know the law. Let me tell you what happened. The day that she went to court for her first pro se meeting, where remember she had to be there, it was really the only one where she sat at the table by herself, right? I think it was the only one. Winston Hobson, I bet he took a vacation day. He went and he curled up on his recliner and he eased back. He probably ordered a pizza. There's no telling. He said, I'm going to enjoy this. And he probably sat there and giggled his ass off. I'm sorry for my cussing. So do I need to go over this part? I guess I don't. We get the point, right? But I think what we're looking at here, though, is how Judge Kranick has outlined each of these things that occurred. Like, he didn't leave anything out in this motion or this order right here. He says the court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson: adversarial relationships, lack of satisfaction, and inability to meet defendants' desires. The court found that all of the defendants' relationships with all court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that the defendant may not be provided another court-appointed attorney and that the defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occurred. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge. The defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. That's where I got it from. So they set the status hearing for the April the 12th. On April the 12th, they held the status hearing. Cashman advised the depositions that had been set. On June 7th, the status hearing was held. Cashman addressed her dates of availability. The defendant was present. Thereafter, the defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism and providing the court with letters dated June 4th and June 7th. Cashman advised to her efforts and time spent on the case so far. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally important. June 11th, Cashman moved to withdraw. And again, he has to lay this out: for irreconcilable differences, including but not limited to ethical considerations. And then on June 28th, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida bar, Schwab versus State, as the basis for the withdrawal. At no time has the defendant refused to accept the services of any of her 7 appointed attorneys. I do like that he put that in there because he's right. She hasn't. She just, that's the only thing she's done right. But I don't think I don't know. Except for when she's like, after they say they want to withdraw, she goes, well, you can't withdraw because I'm going to fire you. Brian. All right. Both the United States and the Florida Constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-representation in all criminal prosecutions. They've referenced various case law here. Forfeiture of right to counsel. A defendant in a criminal case can forfeit a right to court-appointed counsel. Forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. And of course, there's a bunch of case law there. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. As set forth above, defendants recalcitrance to the attorneys who were not conflicted out, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, of Banquets and of Cashman, and personal attacks of Padilla, Banquets, and Cashman. Each of these attorneys were required to withdraw. I just realized that I've got my headphones on again and I wasn't plugged in, so my speaker's going to suck. I apologize, you guys. It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Additionally, the withdrawal of 8 different attorneys, 7 of which were court-appointed, leads to a determination that the defendant had forfeited his right to counsel. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As the court finds defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct a ferreta. Anyway, I don't know how to pronounce it. Or otherwise warn a defendant of the dangers of proceeding pro se. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that a defendant be warned about the consequences of his or her conduct, including the risk of proceeding pro se, which she was twice before. On February the 9th, the defendant was twice advised that another court-appointed attorney may not be provided. On May 10th, the defendant was advised about the dangers of self-representation. On February 9th, the defendant was advised about the dangers of self-representation. So both those times she was. On February 9th, the instant case had been continued 16 times. So wait, I think we're under more than 17 continuances at this point then. I'm not sure. I thought we were at 16 and then the hurricane put us at 17. On June 26th of 2024, this case has been pending 4 years, 3 months, 5 days, from the date of the filing of the information on March 23rd of 2020. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to the defendant's attention on May the 10th of 2022. Defendant complains that Bankiewicz and Hobson, 2 court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, the ways and the means of meeting and communicating were unacceptable to the defendant. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. Therefore, he now orders counsel's motion to withdraw as counsel filed June 11th, 2024 is granted. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for cost to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to the defendant, Sarah Boone, by Cashman at the Orange County Jail. Therefore, Cashman shall file a notice with the court reflecting that the deposition transcripts were provided to the defendant, Sarah Boone, and such notice shall include the date sent and the address of the defendant, Sarah Boone. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Alternatively, defendant Sarah Boone has, through waived by her conduct, her right to court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September the 24th at 2024 at 1:30 p.m. This case shall remain specifically set for trial for the 2-week trial period beginning Monday, October the 7th of 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. I love that he threw that in there at the end, because thank God, because Owens would have been all over this. But I also think that God spoke at this point and said, yeah, I need another week. Any and all pretrial motions in this case must be filed no later than the close of business day on Monday, July the 22nd of 2024, done and ordered in chambers at Orlando County, Florida, this 28th day of June, 2024. Michael S. Kranick, Circuit Judge. Gotta love him. Gotta love him. And then she went pro se. And then we saw what happened when she went pro se. It was Sunday that I uploaded that, her pro se hearings that occurred right after this letter. So it's kind of good that we do this letter now. So with that being said, I think you're all caught up on the docket dive.
There I am. Damn it. I couldn't find the right setting. So anyway, I started that docket dive. I had to finish it, you guys. It may be a little out of sync with where we were today, but I'm going to upload it later on, probably tonight. And I've been checking. I'm not muted. Not muted. Can you hear me? Are y'all making fun of me again? Put a one in the chat if you can hear me. Can hear me now. Not muted. Thank you. Okay. Y'all had me scared for a minute. I was like, oh, not computer issues again. Bama, thank you for being here, honey. I don't know why you're here still with all that's going on in your world, but I appreciate you so, so much. And you don't need to be here if you got something else you got to do. Thanks, you guys. So I just one last look at the docket or at the Twitter feed to see what was, if we have any updates at all with the trial. And I don't see anything new. So what I'll do is tonight I'll put out another update like I did last night. It was a quick thing of what happened today. And then I will have it out for you by probably 7 o'clock tonight, Eastern or Central Standard Time. And then tomorrow morning we'll be live. I'll go ahead and set that up as well. And we'll be live to watch this hearing they're talking about before they do more jury selection. Court TV does have it scheduled for 8 a.m. Eastern Standard Time, I think is what time they have it for. So let's see. Do we read her 52-page rant? Girl, CB, I did a whole video on that. I just uploaded it in my marathon here recently. This weekend I did a marathon, and I did a couple of marathons. And in there's her letter. There's one with just her letters and updates from her motions. And you'll see it. It's marked. It should be chapters. So you can go find her 58-page letter that I did with all of her definitions, for crying out loud. I didn't read all the definitions, though. I wasn't going to do that. All righty. Well, listen, guys, thanks for being here with us today. And once again, we don't have a lot to report yet, but we will hopefully tomorrow have a little bit more. And then hopefully by Thursday, the trial will start and we can settle in and enjoy watching justice being served for Jorge Torrez Jr. Y'all have a blessed day, and I will talk to you very soon.